and welcome to today's webinar, Residential Conveyancing Completion Day Nightmares. My name is Stephen Smith, Country Manager at Stewart Title Limited, and I'm once again delighted to be joined by Ian Quayle, who will be leading today's session, and my colleague Robert Kelly. Good afternoon to you both. Feels strange saying good afternoon, but how are you both?
Hi, Robert. I'm very well,
Yes,
Steve.
good, thank you.
Excellent. Yes, all good here. It's been a 2-week break. I felt slightly alien last Wednesday morning. It's become such a routine doing these webinars, but good to be back online and another session.
It is good. It is good. Stephen,
So, please.
Yeah, can I just say I'm amazed at the sort of interactivity that we've got with delegates, etc. I feel as if there's people that are sort of friends, as it were, or in the conveyancing process. It's quite amazing. And again, I've got to thank you and Robert for organising these things. As I say, from a professional perspective, I think times will get hard. Lots of people are saying they're very busy at the moment, which is great. But the idea of you providing this sort of thing for the benefit of the profession is great. And I'm also delighted, having spoken to Robert yesterday, that you are getting business and getting feedback from delegates with regard to your products, because I do think it's important that just as much as you're supporting the profession, that the profession also support you. So on behalf of delegates, etc., thanks very much to both of you for what you're doing.
No, so thank you, Ian. But I do agree. The relationship building rather strange in virtual times, but it's certainly been great to get to know some people on the webinars, and obviously have some regulars, if you like.
Absolutely, that's great. It's really good.
Before I pass over, Ian, I'll just go through housekeeping items. I'm sure people are fed up with my voice going through this, but as I'm sure you're all aware, you are dialed in through the audio on your computer. But if you wish to switch over to your telephone, you're able to, or not the telephone, sorry, the telephone through the computer. You can do so just by dialing in the number provided and the PIN, and that should allow you in. It's free of charge, toll free, so there should be no issue there. You will have the opportunity, as always, to submit questions to Ian, Robert, or myself throughout the presentation by typing into the questions pane on your control panel. We will have a designated part at the end of the presentation, as per usual, for questions. You can also, as per usual, raise your hand if you want. There's a little raise hand button on your control panel. If you're having any technical issues, sound, whatever it might be, please do get in touch and we'll try and fix that for you. But also, if you would like to speak to any of us over the audio, then you're able to do that. Please raise your hand, ask to be unmuted, and we can do that as well. Finally, we've also included in the handouts today the webinar notes, so you can download those by clicking on the handouts section of your control panel. Again, if anyone's having issues accessing that and they would like to, then please do get in touch and we can sort that for you. Without further ado, I will pass over to Ian for the main part of today's presentation. So thanks, Ian.
Thanks, Stephen. Thank you very much. So hello, everyone. Nice to almost join you, as it were, virtually join you today. What we're going to be doing is looking at some horror stories relating to completion and how to deal with them. And there are a number of, I think, fundamental points to sort of start with. And these really we've mentioned throughout the webinars that we've done. So let's just look at some of those things. The first is to avoid problems, do the simple things well. Make sure that we're communicating with our clients. Make sure that we are communicating with the other side, and make sure that we're not, or as best possible, we don't do things on the hoof. By that I mean we sit back and think about a course of action before embarking on it. The reason I mention that is that on many occasions where a problem has arisen in my past relating to completion, there is a danger that in the sort of heat of the moment, you fire something off that later on you'd regret. You serve a notice to complete without having first of all explained to the client the consequences of that notice. You lose your temper with the other side on the basis that they're not communicating with you, or their failure to complete causes a problem with you and your dependent purchase, etc. All of these things. And you're going to say, well, all right, Ian, it's very easy for you to say that on a sunny sort of July afternoon sitting in your office, entirely different. When we've got 9 or 10 completions to do on a Friday and we're spending all our time dealing with a nightmare scenario. But seriously, if we can adopt those strategies, that will always help. The other thing that I think is important is planning. Now, let me explain what I mean by that. We all have checklists and case management systems for dealing with standard transactions. If we are dealing with volume conveyancing, there are bound to be hiccups and problems with regard to the completion process. So do we have a system for management with regard to delayed completion or the completion nightmare? Do we have standard emails? Do we have standard forms of undertaking? Do we have processes that we can adopt in the event of a problem? Let me give you an example. We may well be an entirely conveyancing-based firm. We may not have any litigators in our office. So therefore, what happens if a problem arises and we need to think about an action for specific performance or an action for misrepresentation, or we want a view before we do something with regard to a delayed completion? Do you have an association with another firm? Is there a local set of chambers near to you with a barrister that will be available to provide advice swiftly and efficiently to assist your client? If you have a property litigation department, is there a system or process for transmission of the file to them or for them to come and assist you with regard to a transaction? I am a conveyancer. I have been all my life a transactional property lawyer. I sometimes describe myself as a combat conveyancer or a contentious conveyancer, but in the main, courtesy of the conveyancing protocol, etc., the idea is that we're a team with the other side with regard to a transaction, and it's imperative that we progress the transaction as best we can. But where the wheels come off, where there is a problem, do we have a system or process in place that we can follow or adopt? I mentioned undertakings. I do think it's important we have a log or a system of standard undertakings that we can give in connection with a particular transaction so that we're not drafting an undertaking on the hoof or providing some form of oral undertaking. Where that is necessary, make sure if you do give an oral undertaking, it is immediately confirmed in writing. And do be aware of the sort of standard issues relating to undertakings. So all of that is sort of general background and sort of peripheral to some important points that I want to make today. Remember that the date for completion will have been set at exchange of contract. I did deal with a negligence claim once where on exchange of contracts, the conveyancers forgot to agree a completion date. And so the completion date was left blank in the contract. Now, I've had some pretty bad days in the office, to be honest with you, but never quite as bad as that, to be honest. But there you go. So, important point, if the completion date has not been agreed, then standard condition 611 provides that completion takes place on the 20th working day after the date of the contract. Remember as well that on exchange of contracts, time is not of the essence with regard to completion. Tip: if you're dealing with a seller or buyer that you don't trust or that you think has a fairly cavalier attitude with regard to completion and contractual obligations, why not, at exchange, specify the date for completion and then specify that time will be of the essence? The significance of that is you immediately short-circuit the process and do not have to serve a notice to complete, where the other side is unable or unwilling to complete at the latest time for completion on the day of completion. Now, I appreciate that getting the other side to agree to that is going to be difficult. I also agree that that may generate a double-edged sword, because just as time is of the essence for the party that we don't trust, time is also of the essence for us as well. But just to be aware of that, and also be aware of the Law Society's conveyancing protocol, which specifies that we are required to consider in advance of completion whether there's likely to be a delay, how to agree communication is to take place until completion takes place. So the protocol requires us to think about issues relating to communication with the other side. Don't forget about communication with your client. And again, if I'm a volume conveyancer, I would have standard letters covering off situations and problems that can arise with regard to completion, so that I can provide the client via email very swiftly advice and guidance in connection with the problem that we're encountering and how that problem could be resolved and the choices and options that are available to the client. Again, in the heat of battle on a Friday, there is a danger that we ring the client, explain the problem to the client, but don't confirm the position in writing to the client. The client doesn't understand, and the client then gives us instruction, or we provide advice that the client doesn't get. And as a consequence, we embark on a course of action that at a later date will be challenged or questioned by the client. So, important. The Law Society Conveyancing Handbook again provides us with some guidance. And I mentioned this in the notes as well, that where we're dealing with a dependent sale and purchase, we've got to ensure that arrangements are made to complete the sale before the purchase to allow funds to facilitate that purchase. Do we do that? With chain transactions, do we specify earlier completion times to enable the easy transmission of funds in connection with purchase before 2 p.m.? Do we advise clients that where completion doesn't take place before 2 p.m., no matter who is at fault, standard condition 612 bites and compensation is payable by the defaulting party? Are we aware that standard condition 612 doesn't apply in connection with a seller where the sale is with vacant possession and the seller hasn't vacated the property by 2 p.m. on the date of actual completion? I'm amazed how few practitioners are aware of that point, and I'll repeat it. If we're acting on behalf of a seller, we're selling with vacant possession and we haven't vacated by 2 p.m. on the date of actual completion, then the clock doesn't start ticking relating to compensation. North Star Land Limited against Maitland Brooks and Jacqueline Brooks, a 2006 case, authority for that particular point. Also, another practical thing, completion, of course, is normally going to take place at the seller's conveyancer's offices. But remember, we can insert a special condition that completion takes place elsewhere. The norm, perhaps, will be the seller's lender's conveyancer, where we're not on their panel, for example. But if we're concerned that our client isn't going to get vacant possession due to tenant or third-party occupation, if there's a need for our buyer client to inspect target property, it's empty and has been subject to vandalism or damage, or where a seller is undertaking works that need to be completed before completion, why can't completion take place at the premises? Now, again, long shot, I concede, but let's just take a step back for a moment and remember a point I made relating to avoiding negligence claims, and with regard to the conveyancing process, ensuring a buyer client inspects target property at completion to satisfy themselves that all is well relating to the property to enable the buyer's conveyancer to release funds. Important to understand that a seller can't alter the location of completion, can't be compelled to do so unless there's a special condition in the contract, because standard condition 622 always gives the seller's conveyancer the choice of location for completion. The golden rules I mentioned on the slide. Preparation is key. Overreaction must be avoided. Clients need to be kept informed. They need to authorize us, to instruct us on the basis of informed consent. Advise clients as to choices. Obvious one, we could serve a notice to complete. If we do serve a notice to complete as a result of delayed completion, these are the consequences. Or we might decide not to serve a notice to complete with all the costs associated and sit back and wait to see just what the problem is. And here I think is an important point. If there's an issue with regard to completion and the other side has been upfront and immediately disclosed what the problem is, and the problem is capable of resolution, then why serve a notice to complete? On the other hand, I'm going to show you some case law later that says you are potentially negligent if you fail to serve a notice to complete where it is appropriate in order to protect your client's interests. I mentioned already the issue of undertakings, and I want to just highlight a number of points. One, use stock undertakings wherever possible. Have an undertakings file online in your system, or a manual undertaking file that you can pull off the shelf to look at undertakings that might suit the situation that you're facing. Ensure all undertakings are confirmed in writing. Make sure undertakings that are given are discharged as swiftly as possible, and that you are released from the undertaking and that you have confirmation of that release. There has to be an undertakings file or register, and we should be noting on files, either paper files or electronic files, when undertakings have been given. I mentioned on slide an important point about who you will accept an undertaking from. Generally speaking, a case of Patel against Daybell's, a 2001 case, highlights, this Court of Appeal decision, that a solicitor isn't negligent in accepting an undertaking to discharge a mortgage at completion unless there are exceptional circumstances. But the point that I make on slide here is significant. Who would you be willing to accept an undertaking from? There are certain situations, certain transactions, and certain forms of undertaking where I want a solicitor to provide that undertaking for me. And the reason for that is that a solicitor, as an officer of the court, is subject to more sanctions in connection with a breach of undertaking than anyone else. Licensed conveyancers, again, are appropriate to receive undertakings from, but I'm amazed how frequently undertakings are provided by unqualified members of staff, in which case we've got to think about the liability relating to a breach of undertaking. Does it attach to the firm or the person that's providing it? I mentioned Patel and Daybell's, and I just want to go back to that case because, significantly, before the Court of Appeal, some expert evidence was put to the court on behalf of the buyer's solicitors that there were circumstances where it would not be advisable for a solicitor to be willing to accept an undertaking. Those were where the amount required to redeem the seller's mortgage exceeded the minimum level of solicitor's indemnity insurance, and secondly, where the mortgagee is not a member of what was then the Council of Mortgage Lenders, what is now, of course, UK Finance. In those circumstances, the expert, who was not challenged by the Court of Appeal, suggested that a solicitor conveyancer could be negligent in accepting an undertaking in either of those situations. So what could you do where there is some vulnerability? Well, I've already mentioned one thing, insist on an undertaking from solicitor. Where we've got a concern that a mortgage debt exceeds the minimum indemnity insurance of the firm, then it might be appropriate to seek a warranty from the seller's solicitor or the party giving an undertaking that the insurance cover exceeds the amount required to redeem the mortgage. Or it might even be necessary in such circumstances to deal with the lender direct with regard to the discharge of the mortgage. The point I'm making with regard to undertakings is quite simple. Be careful. Be careful who's providing the undertaking. Be careful to ensure that you are protecting your client as best you can to ensure that the undertaking can be complied with. Just before we leave this slide, in the notes I make another point that I think is relevant and useful for practitioners that you may not be aware of. The Land Registry, historically, since the introduction of electronic discharge, has been concerned with some lenders and their attitude, their cavalier attitude with regard to electronic discharge. The Land Registry will assist you if you've got a problem with a lender to ensure it complies with its obligations with regard to notifying the Land Registry that a mortgage has been discharged. You can ask the Land Registry's legal department in London to intervene. I've mentioned this on a number of occasions to firms that have contacted me with problems with regard to electronic discharge, and I haven't had any sort of negativity for any of those firms. It seems that when the Land Registry's legal department is notified of a problem, they get on to the lender, and it seems that the lender jumps when the Land Registry's legal department asks what on earth's happening or what on earth the problem is. Moving on, if I can, I want to talk about dealing with delayed completion and talking about some issues that you may not automatically think about. Firstly, if completion is delayed, identify what the problem is. Communication is key, and remember the conveyancing protocol requires it. If there is a problem with regard to the client, be it the seller client providing vacant possession or the buyer client having some form of issue precluding or preventing completion, be wary about sending to the other side copies of emails that you receive. You'd need your client's express authority for such a transmission of an email to your firm. Better, in my view, to summarize what the problem is in your email to the other side rather than simply attaching an email from your client explaining the unfortunate situation that they find themselves in. Next point, given that the vast majority of completion nightmares arise due to the default of the buyer, what I've done in the notes is just reminded you of the need to check that if the buyer is in default or likely to default, that it may well be worth looking at the transaction as a whole to determine whether it might be possible to generate either some form of smokescreen with regard to the delay in completion, or to generate some form of defense to proceedings, or even create a right of action or establish a right of action against the seller. So, again, take a step back and ask yourselves, is there any opportunity, for example, for an action for breach of contract to be brought against the seller relating to a failure to deliver good and marketable title? Is it possible to generate an argument relating to rescission on the basis that the seller has failed to do something? A substantial non-disclosure, for example, an issue with regard to misrepresentation. Remember that the standard conditions of sale do allow rescission to take place due to seller's misrepresentation. So don't just automatically go on the defensive and start thinking about what we need to do as a damage limitation exercise. You know, how much contractual interest are we going to pay? When are we going to be able to complete? What is the problem? What's our client's downside with regard to a claim being brought for breach of contract by the seller? Do have a think about going on the offensive to see if it's possible to bring some form of claim or to have some form of defense to the proceedings that are likely to be brought, or a claim for damages or contractual interest that will be due. I've given the case of Weir against Area Estates Limited, a 2010 case that sort of highlights the point that it may be, and it's always worth checking, that there's been some form of irregularity from the seller's perspective that enables a defence or an argument to be generated. And I've given you an older case, Watson against Burton in 1957, where again, a seller had overstated the size of the property, and there was a misdescription, and a substantial misdescription would allow rescission that would then enable the buyer to escape liability. There's also the possibility of an action for mistake as to quality of subject matter, or a fundamental mistake of fact, which would render the contract void. So don't just think about the position with regard to what can we do, given the seller's going to go on the offensive. Is there anything that we can do? Make sure you're advising the client of choices. Make sure that you receive instruction from the client as to what they want to do. And remember that we're embarking on fairly uncharted waters with regard to proceedings, and therefore we do need a property litigator or counsel to assist us with regard to choices. In the notes, I mention that negligence claims can arise relating to problems at completion. And there is a negligence claim arising as a consequence of a failure to give a client advice with regard to the service of a notice to complete. In the notes, I mention that there is a continuing obligation to advise a client before and after completion relating to the client's circumstances, the transactional position. So it's not enough simply to think about the practicalities of what are we going to do. It's important that we give full and proper advice to our clients. Cases that are examples, Neighbour and Barker, McManus Developments against Barbridge, and indeed others, Mercantile Building Society against Mitchell Dodds and Company. All of these cases highlighting that solicitors had been negligent relating to transactional work, in essence, post-exchange. So, to prevent claims and to prevent problems, does your firm use completion and post-completion checklists? Do you have a checklist with regard to a failure to complete? Does your firm maintain a register of undertakings, and are there policies relating to those undertakings? In the notes, I talk about issues concerning searches, and I want to talk about searches generally and what to do with regard to adverse search entries in particular. Remember a number of things with regard to searches. Firstly, land registry searches are not conclusive in favour of the searcher. If we do a search, we take an interest in land subject to whatever entries are on the register, whether or not they're revealed by the certificate. If we sustain loss as a consequence of a defective search, we're entitled to an indemnity. Remember, if there are adverse entries with regard to the search, that of itself will not necessarily enable us to refuse to complete. It is necessary to determine whether the adverse entry affects what is being offered to us, namely a good and marketable title. As far as land charges searches are concerned, if dealing with unregistered land, I mentioned a case in the notes of Oak Co-op and Blackburn in 1968, where a search was undertaken against an incorrect name. And I've mentioned a later case of Horrell against Cooper, where a search was undertaken in connection with land charges. The search was made against correct road, but a different address to that described in the title deeds. Again, as far as that search result was concerned, the restrictive covenant that had been recorded as a land charge was effective as against the buyer, even though the search result came back clear. In short, check searches, be aware of the fact that there may be adverse entries. Even if there are adverse entries but the search is clear, your client will be bound by them. Section 12 of the Land Charges Act significantly does protect conveyancers because no liability will attach to a conveyancer where a search is correctly submitted, but it will be possible for the victim buyer, as it were, to seek compensation. With regard to bankruptcy searches, do be careful. If a bankruptcy search reveals an adverse entry against a borrower, the norm is for the borrower to be asked to certify that he or she is not bankrupt. But you have to be confident that that client is telling the truth. The certification provided by the client is a warranty, but the warranty is only as good as the client's financial well-being. It might be necessary to undertake a further check with regard to the search to clarify the position. Company searches. Again, I mentioned in the notes that a company search, some people maintain when dealing with registered land, is unnecessary on the basis that everything that is pertinent to the title will be recorded on the register. I don't hold with that and would always want a company search to be undertaken. As far as that search is concerned, it doesn't carry priority, but may advise with regard to insolvency proceedings that are pending against that company. Again, further clarification or investigation may be necessary where adverse entries are revealed by a company search. I mentioned other searches too in the notes. Important point here is make sure that you're getting search results in good time to be able to react in the event of adverse entries. And where there are adverse entries, there are normally a number of issues that require addressing. Point number one, if there is an adverse entry, does it adversely affect the property or impact on the title? Two, what is to happen with regard to the adverse entry? Is it a matter that the seller is going to attend to, and will there be time to attend to it, or is it a matter for the buyer? Generally speaking, it will be the seller to deal with any adverse entry, to determine that it is removed as soon as possible. Only if the adverse entry is relevant to title or adversely affects the property will it be necessary to delay completion. I'm not for the life of me saying that if there are adverse entries, a buyer's conveyancer can sit back comfortably and wait for the seller's conveyancer to attend to the same, nor to accept an undertaking from the seller's conveyancer to remove the adverse entry and to be willing to complete as a consequence. The general rule I have with regard to adverse entries is that the applicant relevant to that entry is the party that must cooperate in order to remove it. The reason I say that is that the only way we're going to get a fairly swift resolution to the problem is for the applicant to be cooperative and to assist in the removal of the entry. Where we're getting no cooperation or reluctance to assist, then we're left in a situation where completion is likely to have to be delayed for a considerable amount of time. So, I mentioned in the notes, an important point, particularly when dealing with registered land, the general rule is that entries can only be easily removed with the cooperation of the original applicant. With regard to notices or restrictions, there are opportunities for challenge or removal, but they invariably are going to take time. And as far as what sort or length of time, it is invariably difficult to say. There isn't a sort of magic fix that will enable me to say a unilateral notice can be challenged and successfully removed within 21 days. We can't say that. I mentioned in the notes a case that I'd like to draw to your attention called Holmes against Kennard. And what we had here was a Homes Rights Notice revealed by a land registry search, an OS1. The seller's solicitors submitted an application form to the land registry that they had signed. It was submitted to the land registry under the false hope that that would be sufficient to remove the Homes Rights Notice. Surprise, surprise, it wasn't. As a consequence of that, the court determined that the seller's solicitors were liable for failing to ensure that the entry was removed, but also that the buyer's solicitors were held to be negligent in failing to ensure the entry was removed. So, important point, where the seller is dealing with the removal of an adverse entry, as a buyer's conveyancer, I would want to see the application or the form that was being submitted. I would want to see the consent of the applicant relating to the adverse entry. In the notes, I mentioned relating to adverse entries, issues concerning notices and restrictions. On slide, there's a problem. So let's have a nightmare. It's Friday. We're completing. Our OS1 that we got in on Thursday evening reveals a unilateral notice on the title. What are we going to do if we're acting for the buyer? Well, we're going to tell the seller, hey, there's a unilateral notice on the title. And the first question should be, what does it relate to? Either the seller's conveyancer or the buyer's conveyancer should have a look at the UN1 and any documentation submitted in support. Remember, where a lay client has made an application for a unilateral notice, the land registry will insist on documentation being submitted in support of that application. Let's see it, and let's have a look at this notice. Is it a notice that impacts on the good and marketable title, or does it adversely affect the property? Remember what we've said in the past. A notice is not a means of validating or legitimizing an interest in land. It is a statement by a party to claim to have an interest in land which the land registry is willing to accept. Unilateral notices can be subject to cancellation, but the applicant must consent. They can also be subject to challenge, and they can also be subject to an application to Section 77 of the Land Registration Act 2002 for loss that is sustained as a consequence of a notice being placed on the title without reasonable cause. Cancellation is going to be quick. Challenge is likely to be slow. Challenge is probably best effected by way of application to the court. As to that application, I've got a really useful tip that I'll give you a little later on. If the interest was protected by an agreed notice, cancellation is the only route available to us, or application to the court for a declaration as the enforceability or otherwise of the agreed notice. Remember, the right to challenge is not available. The next point to note that I think is significant is that there is a case called Nugent and Nugent, and again mentioned in the notes, concerning unilateral notices and the availability of challenge. A court, the High Court and indeed County Court, has jurisdiction to determine an application for cancellation of a unilateral notice. And in Nugent and Nugent, the High Court examined what jurisdiction a court had. And the important point that the court emphasized was that a unilateral notice was subject to removal courtesy of Schedule 4 of the Land Registration Act 2002. In essence, that Schedule 4 gives the court a discretion to rectify a title. The title is rectified by the removal of the unilateral notice. I'm going to show you a swift way of making a summary application for removal of a unilateral notice or an agreed notice by way of cancellation, courtesy of what's called a purchaser vendor summons under section 49 of the Law Property Act 1925. We're going to have to wait for a moment or two before we look at that in any detail. As far as restrictions are concerned, remember that we've identified in the past restrictions are not cast in stone. Again, on slide, there's a problem. We're completing. We've identified there's a restriction on this leasehold title requiring landlord's consent for assignment, and the landlord is a dissolved company. What can we do? Companies, what can we do with regard to the fact the company's been dissolved? We can apply to reinstate the company. Probably going to take us between 3 and 6 months and might be very, very expensive. The last one I did, was a requirement to pay outstanding fees to Companies House and also outstanding tax that cost the client nearly £12,000. You can, of course, seek removal, disapplication, cancellation, or modification of the restriction. And again, within the notes, I've given you detail. Important point to note that disapplication in form RX2 would require you to give evidence to the land registry as to the steps you'd taken to comply with the restriction or to see why the restriction couldn't be complied with. Remember, restrictions are not cast in stone. Remember, the party placing the restriction on the title can join in an application for cancellation. I've given you details within the notes, and I've also mentioned that as far as disapplication is concerned, this is a temporary measure that means that the current disposition does not have to comply with the restriction, but future dispositions or registrations of disposition, more accurately, do. The next point I want to explore is a case called J.A. Singh against Liange, which I mention in the notes. It's a 2010 case, but it highlights that restrictions have to be placed on the title and must be necessary or desirable to protect an interest in land. So again, we could use a purchaser vendor summons to challenge a restriction to seek cancellation on the basis that it does not comply with the J.A. Singh test in the 2010 case. I'll say it again, that the restriction is necessary or desirable to protect an interest in land. Section 77 is available in connection with restrictions just as much as it is with regard to notices or cautions against first registration. For Section 77, loss must be sustained in order for a claim to be successful. And Section 77 is intended to discourage the misuse of restrictions, notices, and cautions against first registration. It is not a means in isolation of dealing with the removal of restrictions or notices. And I want to talk about delayed completion. And the first thing that I think is important, if there is a delay with regard to completion, does the client need to know about the standard conditions of sale? And I mentioned the case of Walker against Boyle, 1982. This case highlights that it's not necessary for you to dissect the standard conditions of sale and to go through each and every one with the client that's in difficulty or that is encountering problems with regard to delayed completion. We don't have to do that, but it might be necessary to spell out to the client what the client is entitled to do or not do relating to the problem that we're currently encountering. The important point to be aware of with regard to this is that the lawyer must be careful to explain to the client their rights and obligations. so that the client then has a choice as to what to do in connection with the transaction. I mentioned in the notes about the duty that a solicitor or conveyancer owes in connection with the defaulting or innocent party with regard to a delayed completion. The important point is that you do owe a duty of care to advise the client of the choices that are available to them and to advise them as to the best method of limiting potential loss or liability. I've also mentioned in the notes P&P Property Limiters and Owen White, Dreamvar Mishkonda Rea, on the basis that there is the potential for liability for a seller's conveyancer and buyer's conveyancer relating to seller identity fraud, highlighting the point relating to being aware of property fraud throughout the transaction, including the position at completion. If we are dealing with a delayed completion, point number one, the innocent party is entitled to compensation, the contractual interest that the contract provides for. But, interesting point, your client can also recover the actual loss that they sustain as a consequence of breach. I dealt with years ago a situation where a client was buying a residential property to convert into a dental practice. We knew that the seller was going to be unable to provide vacant possession on the day of completion. The day before completion, we notified the seller of our client's intentions with regard to the conversion of these premises into a dental surgery, and advised that if the seller was unable to complete, then we would be seeking actual loss, the potential for financial loss arising as a consequence of the delay that would transpire in converting the residential property into commercial premises. In those circumstances, we didn't claim contractual interest, we claimed actual loss. You're perfectly entitled to do that, but significantly, of course, you're not entitled to claim both. I mentioned that as far as completion is concerned, there are a number of points relating to delayed completion. One, identifying client's position contractually, an entitlement to contractual interest and or actual loss. A delay in completion without good reason is going to amount to a breach of contract, but that of itself should lead to the need for the innocent party to serve a notice to complete. But the parties, the innocent party in particular, may have a right to terminate the contract due to breach, and a buyer who is defaulting may be able to escape liability where a seller is unable to provide title that it has contracted to sell. I'm going to move on a little bit and just emphasize a particular point that I think is important that I touched on a little earlier. It is imperative that we give consideration to the service of a notice to complete where our innocent party client is at a disadvantage as a consequence of a buyer being unable or unwilling to complete, or a seller unable or unwilling to provide vacant possession. So we should always determine, with regard to a notice to complete, the points I make on slide. Is the innocent party ready, willing, and able to complete? So are the conditions necessary for the service of a notice to complete in existence? Has our client been told about the requirements for service of a notice to complete and the consequences of serving such a notice? Because just as much as it imposes a time limit on the defaulting party, it also imposes a time limit on the innocent party. Does your client know that? I've had situations, I may have told you this in the past, where I've acted for clients who said to me, wind up the other side and get them to serve a notice to complete. And you think that's absolutely ludicrous. But what they've wanted to do is to have a notice to complete served on them so that they know they've got 10 working days in which to comply with their contractual obligations. Contractual interest Any legal costs associated with the delay are of no consequence to the client. They just want some more time to get their act together to complete. Williams against Glenowen and Company, a 2003 case, states that in certain circumstances, a failure to advise a client about the availability of a notice to complete will amount to negligence. I am not advocating that you immediately, where completion has been delayed for whatever reason, serve a notice to complete. I'm simply stating that you should be telling the innocent party that they have the right to serve a notice to complete and that you will do so if instructed. But I'm not saying just do it automatically, far from it. It is important to understand, with regard to a notice to complete, a number of important points. That a notice to complete, if it expires, will enable the innocent party to rescind the contract. But it is also possible to terminate the contract contractually, and I mention details in the notes. A right to terminate a contract is a contractual remedy, and the standard conditions of sale and the standard commercial conditions of sale provide for a right to terminate the contract in certain circumstances. So in addition to the thought of serving a notice to complete in order to enable an innocent party to terminate the contract, it is input by way of rescission. It is important to understand that the standard conditions of sale will allow termination without the need to serve notice to complete in any event. As far as the notice to complete is concerned, there are a number of issues that I think are significant. It is possible to waive the statutory and contractual obligations that a notice to complete generates. It is possible to serve a second notice to complete whilst an existing notice to complete is live. That would constitute an implied waiver of the first notice, but you can't extend the time for an original notice to complete. You can agree to extend the date for completion by way of creation of a new contract, but to do that, you must be compliant with Section 2, subsection 1 of the Law of Property Miscellaneous Provisions Act, 1989. It is possible for an estoppel to be generated, precluding an action being taken by an innocent party as a consequence of delayed completion. So you may, by conduct, either you acting on behalf of the innocent party or the innocent party themselves, generate an estoppel. But I've yet to find case law where that estoppel has been successful. The one case where it was seen was the case that I mentioned earlier, North Star Land against Brooks, 2006. In this case, on the day of completion, the solicitor for the buyer suggested that the parties should agree a variation to the contract and that completion should be postponed for a 7-day period. Seller's conveyancer said, I'll need to take instructions and get back to you, but then didn't. The defaulting party's conveyancer, clutching at straws in my view, argued that the failure to get back to report what the seller instructions were constituted an estoppel. Not surprisingly, the court said no. Their argument was that a reasonably competent conveyancer or solicitor would not think that a failure to respond in those circumstances was an agreement to postpone completion or generated an estoppel. The sellers were perfectly entitled to rescind the contract as a result of the buyer failing to complete on the contractual completion date. Again, interestingly, North Star assists us with regard to looking at what we mean by a notice to complete and 10 working days. The court emphasised that a working day ends at 5:30 or 6 p.m, depending on how or what time the office was open or closed, and that if completion monies arrive after 2 p.m, they are deemed to have arrived on the next working day for the purposes of calculating contractual interest. Important to understand that all a notice to complete does is generate time being of the essence, and where a notice to complete is not complied with, that gives the innocent party, the server of the notice, an opportunity to rescind. Significantly, it does not allow the innocent party, if it's the seller, to retain the deposit, or the innocent buyer to immediately seek the return of the deposit. That is subject to section 49(2) of the Law of Property Act 1925, which gives the court a discretion as to what is to happen relating to the deposit. On the topic of deposit, where the buyer has paid a reduced deposit but then is unable to complete, remember the buyer is under a contractual obligation to pay to the seller's solicitors the remainder of the deposit. The chances of that happening are slim, and it is obvious in circumstances such as the buyer defaulting on completion that the seller will have to sue for the payment of the balance of the deposit. That's why whenever a seller agrees a reduced deposit or a buyer offers it, I would always warn the seller client of their vulnerability in the event of buyer default at completion. I mentioned in the notes about the service of a notice to complete. It should always be served by fax. And the reason that it should be served by fax is this is the fastest method of deemed service, notably 1 hour after the notice is sent. So don't serve by post, even if the contract permits it. Don't serve by email, serve by fax. And remember that point that I emphasized, we're serving a notice to complete to make time of the essence, to enable our innocent party to rescind the contract on the basis that if we're acting for a seller, we're going to be retaining the deposit. We should warn our seller client that the position is that there is no guarantee, courtesy of section 49, that the deposit is entitled to be kept. Remember what I said about notices to complete. They should be served when the party serving is ready, willing, and able to complete. There is no requirement to remain ready, willing, and able throughout the notice period. Authority for that, Count Pack Limited against Pack Southern China Property Investments, which is a 2018 case, which is quite interesting, and which I've given you in the notes. Middle against Park Lane Investments, a 2008 case, confirms that minor outstanding administrative matters would not preclude a party from being ready, willing, and able to complete and to serve a notice to complete. The other point that I think is significant with regard to that case is that it is necessary for the party serving the notice to be compliant just as much as the recipient. I've given you loads of other cases relating to notice to complete, which you can look at. In particular, I draw to your attention the case of Hakimzade Limited against Swales, which is a 2015 case. The interesting feature of that case is that the case highlights the position as to what is to happen concerning deposits, and also highlighted the fact that it was possible for a summary application to be made, either seeking specific performance of the agreement or a claim for valid termination and an argument for a declaration that the contract had been validly terminated. Very interesting case, quite a recent case, highlighting a number of issues with regard to procedure concerning notices to complete. The next thing I want to talk about is the repudiated breach and the right to terminate, looking at standard conditions 7.4 and standard conditions 7.5, and the requirement of the payment of deposit or payment of balance, which I've touched on, and also the right of the buyer to terminate the contract and demand repayment of the deposit plus interest, and the seller's right to terminate the contract, forfeit the deposit, and keep accrued interest and resell the property and claim damages. Important point. If your client can't resell, then he can't determine what the damages he's entitled to should be. So what you can do is put a special condition in the contract, particularly for new builds where the market is jumpy, to say that where the seller is unable to resell and can't therefore determine what his loss is, the property will be valued at some date in the future and the loss calculated as the difference between sale price relating to defaulting sale and valuation as of date of valuation. I've seen that used, and quite a useful mechanism for determining loss that's sustained as a result of buyer default. I saw that in the last recession in particular, where buyers were walking away from deposits on buying off plan new developments. I mentioned Section 49 of the Law Property Act 1925, Section 49(2). In the notes under heading 6, remedies, I've given you a lot of detail with regard to how a court exercises its discretion with regard to 49(2). Have a look at it. It's thrilling reading. There's lots of cases there that give you a flavour of what the courts decide and what their thinking is. So you can have a look at all of that. In addition to that, I mentioned the seller's remedy of specific performance and given you a health warning relating to specific performance, particularly due to the fact that it will not be available if damages are available. It will not be available if the innocent party is delayed taking action. Significantly, it is possible to claim specific performance before completion. So if I'm buying and you're selling, and I tell you 3 days before completion my buyer has had his mortgage offer withdrawn and therefore can't be completing, your client could issue proceedings for specific performance. Remember I told you about that client of mine that urged me to encourage either side to serve a notice to complete. Why did he do that? Well, he's quite a wily old character. And what he said is, if they serve a notice to complete on me, I've got 10 working days to effect completion and I don't have to worry about specific performance. So that was quite a clever little trick on his part that he transmitted to me and I've just transmitted to you. Rescission, I've given you details in the notes. I've also mentioned that rescission is available contractually due to misrepresentation, due to misdescription, and due to non-disclosure. I've mentioned in the notes how damages are calculated. You can have a look at all of that. I want to draw to your attention item 7 in the notes, namely the vendor-purchaser summons. Courtesy of Section 49 of the Law Property Act 1925, most practitioners are not aware of the availability of this application. It enables a summary application to be made to the court where requisitions or objections or any claim for compensation or any other question arising out of or connected with the contract can be made to the county court or high court. If you want a quick fix as to whether or not an activity is lawful, a notice to complete is valid, a party is in breach or not, or otherwise, a vendor purchaser summons is potentially the answer. It gives you a quick, cheap fix with regard to a court making a determination relating to a dispute. The last thing I want to talk about today is completion issues and residential leases. And the first thing is, if we've got a defect in a residential lease, can that prevent or delay registration by a buyer's conveyancer? Potentially it could, but that would that enable a buyer to be able to refuse to complete? Probably not. I mentioned in the notes that restrictions in residential leases may be incapable of compliance. Would that enable a buyer to refuse to complete? Again, it depends, but probably would be my answer. And the last thing I want to talk about, and the thing I want to feature just before we finish today, is post-completion issues that can't be complied with. Deeds of covenant, notices of assignment, notice of charge, fees payable. I've given you a lot of information about how we can challenge fees that are being demanded from a landlord. And the important point here is that those fees are administration charges that ought to be reasonable. So the lower tribunal has provided guidance as to fees for deeds of covenant with consent to let, a charge of £80. Grants of consent between £40 and £165. Notices of assignment, notice of charge, fees for receipting or acknowledging receipt, £40 to £50. I am conscious, Stephen, that yet again it's irregular, isn't it? We've overrun. And I'm also conscious that I could spend a day dealing with particular features that we've sort of touched on by way of broad brush this afternoon. But I'm going to stop and I'm going to ask, A, are there any questions? And B, are there any questions in the chat box that we need to address, Stephen?
Absolutely, thank you. And yes, we have had a few questions, and just a reminder to anyone that if they do wish to ask a question, they can either do so by raising their hand, and we will unmute you, or by asking a question in the questions pane. Ian, just quickly, I was conversing with someone over email, Liz, I believe she's on the webinar today. And I said, perhaps you could open this up and ask people about their completion day nightmares. And she said, don't do that because we'll be here till tomorrow. So.
Yeah. Oh, I mean, I've seen everything and everything. The worst I ever saw, Stephen, was a situation where sellers, the night before completion, husband and wife argued. Wife basically maintaining, I don't want to sell the house, I don't want to move out. Altercation involving the police. Wife sets fire to the house, damages it severely. Husband arrested and locked up. What do you do? What do you do? There was an issue there with regard to insurance and a problem relating to insurance. Luckily, in the end, the parties agreed a walk away. But people think, oh well, insurance isn't an issue, or nightmares aren't an issue. The banking system failing. I've seen a problem where a firm was intervened on the morning of completion, and the firm that was acting for the buyer contacted me to say, could I accept an undertaking from a fee earner that was working from home in the knowledge that the firm had been intervened that morning? And the answer to that was definitely not. So you see everything and everything, to be honest with you. Most Fridays are a nightmare for most fee earners, I think, is the only conclusion I can draw, Steve. Anyway, any other questions?
Yeah, so so question from Nia. Nia asks, does the notice, I assume notice to complete, have to be signed? I had one not signed and only received. Sorry, I was just going off the page there. Where are we? Sorry, Ian.
I can answer the question.
Only received by email. Yes, yeah.
Yeah. I've seen a county court decision of a judge where the notice wasn't signed. The notice had the wrong address on and the wrong parties, but the court said it was a valid notice on the basis that the recipient knew what the sender was intending to do. So my view would be that adopting that attitude, a court would be likely to say that was a valid notice. But what you could do in that situation is test it by way of the vendor purchaser summons that I mentioned under section 49(2) of the Law Probity Act 1925, and just ask a county court or a high court judge to determine its validity. But my gut reaction is a court is likely to say that's a valid notice because the recipient, we assume, knew what the sender was attempting to do with regard to the notice.
Excellent, thank you, Ian. Yeah, we have another question from, a couple from Adrian, actually. So the first one from Adrian, he just asked, why did the SRA word 6.12 as it did?
Yeah, I don't know the answer to that, unfortunately. Don't know why they did it. I mean, what they've attempted to do is try and clarify the position, but in fact they've muddied the waters, to be honest with you. So good question, Adrian. I don't know is the answer, unfortunately.
Absolutely, thank you. And the follow up there,
Yeah,
undertaking. There was a suggestion that partner or director signs undertaking, not just solicitor or CLC. Sorry, question
yeah,
mark.
yeah. The cases seem to suggest, and Patel and Dabos seems to suggest that it is a solicitor, not necessarily a partner. But I would agree with Adrian that being the cautious chap that I am, I'd probably want the partner to sign it. Where it was a significant undertaking with potential vulnerability for non-compliance. Yeah.
Yeah, no, that makes sense. Thank you, Ian. Just very quick, a comment. Sorry, the writing's a bit covered on my screen today, so I'm having some problems, but I'll try and do as best as I can with this. So it's more of a comment than a question, but I mean, feedback, obviously welcome, Ian. So from Robert, he asks, not a question, but a comment regarding a seller solicitor undertaking to redeem a mortgage on a sale. I had a matter years ago, because fortunately enough, no such undertaking had been asked for or given, where the existing mortgagee for my selling client refused to accept the redemption monies as the mortgagee thought that the purchaser was buying with tainted funds and mortgagee did not want to be seen in receipt of POC or tainted monies. Clearly, the
Right.
mortgagee disclosed this to me at the time, leaving me somewhat in limbo and having to fend off demands from the buyer's lawyer for a deed of discharge. The position resolved itself after 2 weeks, no doubt after the mortgagee received clearance. Just a warning
Yeah.
note, giving undertakings to redeem a mortgage on a sale can be dangerous for the selling solicitor.
Yeah, absolutely. Stephen, my boss, my first boss, probably the best lawyer I've ever worked with, gave an undertaking once that cost the firm, I think it was over £250,000.
Wow.
Just a mistake made in a similar way to what Robert was saying there. And
Yeah.
the point is, yeah, there could, you've got to think about the situation. I think that situation couldn't arise now because of UK finance and the handbook. I think there's an issue about that. But what I'm going to do, I'm going to check that up because it's an interesting point that potentially could be problematical today, I think. But I'm just somewhere in my mind, I think UK finance deals with that issue, so I'm going to check it. That's my homework, Stephen.
Sounds good, thank you. And I'm so sorry, my son has walked in on the webinar room. There's a couple of questions from Zara. I think we've just got a moment to get through these. So if we don't serve a notice to complete, but the defaulting party is able to complete a few days later, is the non-defaulting party entitled to claim interest stroke compensation as
Yes.
part of the completion monies?
Yes. Yeah. You can't claim legals unless you put a special condition in the contract, but you can claim contractual interest.
Perfect, thank you, Ian. And the follow-up there is it worth our time arguing with management companies stroke landlords regarding their fees? I think maybe slightly
Yeah,
tongue in cheek there, but
great question. I would always pay the fee under protest and advise the client that it's possible to make application to residential tribunal, lower tribunal by way of written representation. Cost your client £113 and they can challenge the fee. And if they're successful, they get their £113 back. And it's the application process is very, very client friendly. So there's no need for you to get involved. So I say that again, I wouldn't, I don't argue. You probably haven't got the time or the inclination to argue with the management company. Pay it, but pay it under protest, and then say to your client, if you want, you can challenge and seek the money back. Most management companies and landlords will not want to go to a tribunal. And the reason for that, if a tribunal makes a determination that a fee is unreasonable, then they have to stick with that fee. So if a tribunal determines that a fee for notice of assignment is £50, a landlord can't charge extra in connection with future fees for receipting notices. So what they're likely to do is to do a deal with you. If they do a deal with you, they can then ask for the exorbitant sum at a later date from future sellers, or from future buyers, more accurately. Yeah. If Zara wants information on that, I can send her a link to the Leasehold Advisory Service website about how you make the application. But the client should be able to make that application themselves. The key is to make sure if you pay it under protest. Don't just pay it, because if you do pay it, you lose the client's right to challenge it at a later date.
That's great, thank you, Ian, and hopefully that's right, Zara. I think you preempted that response there, Ian, because Zara has actually asked for that. So, yeah, Zara will be in touch after the webinar. In maybe 2 or 3 more, and I think then we'll close off the session. So, Jane asks, what about riders to a contract post-completion whereby the date agreed cannot be met, not leasehold matters? And then she comes back and she clarifies that the date to the rider, that is.
Right. So what Jane is saying is, if we vary a contract, well, yeah, what you do there is that the contract that varies the original contract will be subject to the same standard conditions of sale. So all that I say with regard to a notice to complete, etc., would apply to the variation contract just as it would to the original contract. I think that's the point that Jane is making. If it isn't, if you ask her to drop me a note, I'll explore and clarify it. And again, that can go in our book of questions and answers, Stephen. Yeah.
Absolutely. Yes. Increasing by the week, Ian.
Increasing by the day, Stephen. By the day.
Yeah, indeed, yes. So yeah, perfectly. Alistair asks, what should you do when the sellers leaves? I'm not entirely sure. Actually, I'm sorry, Alistair. I might leave that question. I think it's to do with asbestos sheets.
All right.
At completion, I guess. But
yeah, the point there would be that the seller is obliged to provide vacant possession. There's quite a lot of case law on what vacant possession means, but it means that the buyer can reasonably enjoy the premises that he's acquired. So if there's asbestos or any other contaminant, that would preclude enjoyment. That would mean the seller has not provided vacant possession.
Perfect, thank you, Ian. And yeah, I think that answered that, Alistair, but please do get in touch if that's not what you're asking. So the final question, I think, Ian. So if completion has been delayed, but the seller and purchaser can agree a new completion date as they have a good relationship, does a new contract have to be completed? And that's from David.
Yeah, well, it should be. I mean, you could have an exchange of emails, but technically you would create a new contract.
Yeah.
Yeah.
Yeah. No, I think that makes sense. I think I'd certainly feel more comfortable. I think
the way I would deal with that, Stephen, is I would exchange hard copy letters that would constitute the variation agreement. That's how I would deal with it.
Absolutely. Thank you, Ian. So I think that's all the questions. Thank you, everyone, for the questions. Lots of questions there, lots of good questions.
Yeah.
And thank you to everyone for attending and staying on, obviously at 1 hour and 20, so running a bit over time.
Sorry about that.
No, not at all, not at all. As usual, if you have any other questions, please do contact myself, Ian or Robert. As is usually the case, you will receive an automated email tomorrow from the GoToWebinar system. If you reply to that, that will come directly to me, and I can share that with Ian and Robert. But yes, I mean, please do get in touch. Otherwise, if you do have any other questions, just leave me say on behalf of Ian, myself, and Robert, and you all for joining. Thank you, and we look forward to seeing you again in a couple of weeks' time. Have a great rest of your day, and goodbye.